behalf of the HRIA, welcome to this morning's presentation by Evelyn Marcou from MST Lawyers, our HRNet providers. Although HIRE20 was unfortunately cancelled due to COVID-19, the HRIA National Office thought this was the perfect time to produce a series of presentations designed to provide advice for our members navigating through this difficult time. The HRIA National Office spent the first couple of weeks after the crisis hit calling all of our members to check in and see how we could assist. From these conversations, we understand that some of our members have been hit very hard, while others have seen opportunities to pivot their business and even experience areas of growth at this time. Whatever your situation, we have designed these presentations to assist and provide updates to all members. I want to thank our sponsors who were on board for HIRE20 for their support. We look forward to working with them once more when we're all back together at our convention on the Gold Coast in May 2021. Today, we will hear from Evelyn about how COVID-19 has affected commercial and retail leasing laws in Australia. But before I hand to Evelyn, I'll run through some housekeeping. We have the question and answer functionality active during this webinar. If you have a question during the presentation, please post it here. And if we have time, we will answer it in the dedicated Q&A session at the conclusion of the presentation. We do have questions that were sent through prior to this session, and we'll be answering these first. If you have a question that is of a more sensitive nature, please reach out to MST Lawyers, our HRNet partners, using the contact details provided in the member section of our website. We will have the chat function set up between the attendees and the host during this webinar. So if you're having issues hearing or seeing the presentation, please post this on chat. We've also enabled a live poll during the webinar, and we encourage you all to participate to ensure we have a complete understanding of everyone's situation. Lastly, the webinar is being recorded, and the recording will be made available to all members in the coming days. I will now hand over to Evelyn.
We are, James.
Go for it.
Welcome everybody, and thank you for your attendance today. Today I'm going to talk about the COVID-19 situation, how it has affected commercial and retail leasing laws in Australia. I'll start with talking about, which I'm sure you've all heard, the National Cabinet Mandatory Code of Conduct. So that was the first thing to be announced by the government when COVID-19 started to impact the world and particularly our country. On the 7th of April 2020, the National Cabinet announced the code. The purpose of the code was to set out a set of good faith leasing principles for application to commercial tenancies, including retail, office and industrial leases. So the code was enacted to basically apply for all tenants who are suffering financial stress or hardship, where the tenant is eligible for JobKeeper and has an annual turnover of up to $50 million. So it had to be an SME tenant. For franchises, the turnover threshold was applied at a franchisee level, which meant that where you've got a situation that there's a franchisor and franchisee in premises, it would be the franchisee's turnover that would be relevant for the test, the $50 million test, not the franchisor's income. While not mandatory for tenancies which do not meet the JobKeeper eligibility and turnover criteria, landlords are in general encouraged to apply the code to all leasing arrangements. Now the code was given effect through every state and territory through legislation or regulations appropriate. I've got to make the point too, a lot of people didn't understand that the code is just a code. It's a set of guidelines. It's not actually the law, so you can't really enforce it. You can quote the code, you can try and negotiate pursuant to the code, but the code was just set up to be a set of guidelines and almost to be treated like a second reading speech. So when each state and territory enacted their regulations, the code could be read alongside those regulations. So the next thing that came out in Victoria, I'll talk about Victoria first and I will talk about other jurisdictions. In Victoria, we had the COVID-19 Omnibus Emergency Measures Act come out. That was passed in Victoria on the 24th of April. That particular act, as with the other jurisdictions, was like an overriding act that amended lots of different acts that need to be amended as a result of COVID-19. So the Act allows regulations to be created to give effect to the actual mandatory code of conduct. The highlights of the actual Act itself was it allowed regulations to apply to retail, non-retail, commercial and industrial licences. It defined an eligible lease. So an eligible lease is one that is basically either a retail lease and was in effect at the time of the regulations being enacted. So it had to have been in effect by 29 March 2020. And it also referred to the $50 million threshold test for an SME entity. And in the particular Omnibus Emergency Measures Act, it actually referred to a very complex set of grouping provisions for those who might be caught by grouping provisions for the purpose of there being an SME entity. And the Act also made it clear that it would apply to a head lease, a sublease and a licence separately. The next thing that came in for Victoria finally on the 1st of May was the actual regulations with their lovely long title, Omnibus Emergency Measures Commercial Leases and Licences Regulations 2020. And as expected, they were actually retrospectively applied from the 29th of March 2020 till the 29th of September 2020. So these laws are here for a 6-month period. It's called the relevant period, the pandemic period, some people refer it to. So the laws in Victoria are deemed to apply from 29 March to 29 September 2020. What is interesting in Victoria about that start date, which differs to other states and territories, is that there were a group of landlords, actually a lot of landlords, who thought they would be smart and draw on tenants' bank guarantees for non-payment of rent either at the end of March or mid-March, even in April, they were doing it in April. But what this law has done is made that actually illegal and a breach of the Act. So a lot of landlords who did draw down the bank guarantees after the 29th of March are actually in breach of the Act. So we've now got this set of laws and regulations. The regulations in Victoria mirrored the National Cabinet Mandatory Code of Conduct probably as close as possible than the other states and jurisdictions, but there were some notable differences. So you probably would have all heard about this discussion about proportionality, and it's a word that is being used around the country about, if you're 50% down in turnover, therefore you should have a 50% reduction in rent. That principle of proportionality was really important, but it didn't actually translate and get mirrored in our regulations. It talks about it loosely, but there was no principle of proportionality spelled out in the Victorian regulations. The Victorian regulations do provide that a tenant under the eligible lease may request rent relief from the landlord. They set out the process for it. So the process is quite strict. It's pursuant to Regulation 10.2. So if you are a tenant and you are seeking rent relief from your landlord, in order to get the protection of the regulations, you have to do a few things. Firstly, you have to basically give the landlord a statement that you are an eligible lease and you're not excluded by the corporate group provisions of the Act. You've got to give the landlord evidence that the tenant is an SME entity, so that's that $50 million turnover we were talking about before. And what was different with the Victorian regulations too compared to the code is that they said in their regulations, the tenant must qualify for and be a participant in the JobKeeper scheme. So it goes that one step further. You can't just qualify for it, you actually have to be participating in the JobKeeper scheme. Once that request is made, the landlord's got 14 days or a different time frame if agreed by the parties to make an offer of rent relief. Now, what's happening in actual practice is a bit different to what those regulations say, because once that request is being made to the landlord is then coming back to the tenant, and rightfully so, asking for information about turnover. So that's where it gets a bit tricky, because there's nothing in our regulations in Victoria talking about the proportionality. The Victorian regulations also went a bit further and allowed a landlord to take into consideration their own circumstances as well. So we'll move on to that in a minute. The regulations also provide the landlords, as mentioned below, when I talked about all the circumstances of the eligible lease, what was really important in that particular section was it allowed the landlord to take into account, for example, if they are a self-funded retiree and that's their only form of income, that would be something a landlord could take into consideration in offering rent relief to the tenant. What is clear from the Victorian principle regulations and all other states and jurisdictions regulations is that any offer of rent relief made to a tenant, half of that must be rent waiver. Now, rent waiver means you never have to pay it back. So basically it's a rent reduction. The other half of that has to be deferred rent. So the deferred rent starts after the relevant period has been expired, which is 29 September in Victoria. So you have to pay back that half of the deferred rent starting after the end of the pandemic period, and you have a minimum 24 months to repay that. Another interesting thing is how they have to take into account, here we go, the reduction in the tenant's turnover as well. So I guess one of the big questions people have had is how do you prove what your reduction in turnover is? And that's been the cause of contention between landlords and tenants. Landlords want everything. They have been asking for a whole host of information from tenants. They've been asking for profit and loss statements for 2 to 3 years. They've been asking for literally every bit of information they can get their hands on. Tenants, on the other hand, don't like giving too much information to a landlord. And the reason being, financial information is a powerful tool for a landlord to have. So if you've got a lease and it's coming up for expiry and it doesn't have, for example, an additional term, the landlord can basically come to you and say, this is the rent that I want for the start of a new term if you want to stay in your premises. If they've got your financial information, they know how much money you're making. That will definitely be used against you by a landlord. So that's why we've got this conflict at the moment between landlords and tenants. What kind of information should they be providing? Interestingly, in Victoria, the Small Business Commission finally released frequently asked question guidelines a couple of Fridays ago, and we'll get to that shortly. And that talks about what a landlord cannot ask for and what a landlord can ask for. So we will get to that. The other consideration that was interesting that went outside the code is about the landlord's financial ability to offer rent relief. So we talked about the self-funded retiree, but this would also cover a situation which is happening a lot, where landlords are only able to get 3 months deferred or a freeze on their loans for their commercial loans with their bank. So a landlord might be able to take that into account when they're offering rent relief to a tenant, because if they can only stop or hold their repayments for 3 months, and then they have to continue with their repayments after that, that's obviously something that will affect their ability to offer rent relief for that period of 6 months. What is clear though is that any offer that the landlord does make under the regulations has to be for the whole pandemic period. And finally, with outgoings, that's a big thing too. A lot of people have been asking, well, what about outgoings? How does that all work? So the Victorian regulations, I think, very intentionally used very different language to the rest of the provisions in the regulations, because when it comes to outgoing, they talked about must consider, not must, but must consider, so it wasn't mandatory language, reducing or not passing on outgoings to a tenant. Now, as you can appreciate, outgoings are third-party costs. They're not going into the landlord's pocket. They're things that they pay for and have to pay for third parties. The reality is no one's giving landlords any concessions. Other than land tax, there have been some land tax concessions, which if your premises are deemed to be a retail lease in Victoria, therefore the Retail Leases Act applies, you wouldn't be paying land tax anyway. I can't see how there will be any reduction in outgoings being able to be passed on to tenants in any event. There may be things, for example, if you're paying for cleaning charges and you will close down, obviously you would want to check your outgoings to make sure you haven't been charged for cleaning that hasn't taken place. So we'll talk about the different states and territories now and where they're all at. But before we get to that, I just want to make a quick comment about generally the problems that I've seen coming up in the last 6-7 weeks between landlords and tenants. As mentioned before, the biggest problems being what type of financial information has to be provided. The Small Business Commission did release those guidelines I spoke about in Victoria. I know New South Wales has the equivalent as well. They've basically said, and I'll just read from our regulations, a landlord can ask the tenant for information extracted from an accounting system, extracted from BAS, and provide to a financial institution. So as you can see, that's not very helpful because what does that mean? If you take, for example, the provide to a financial institution example that they've put in these guidelines, as you would know if you've ever applied for a loan, you give them basically everything. So it hasn't helped us, but it has basically given a bit of information about what a landlord's not allowed to ask. So this is where it gets a bit tricky because the two kind of don't correlate too well together. A landlord should not request future cash flow projections, request balance sheet, profit and loss or year-to-date financials, request the tenant's bank balance, require the financial information to be verified, examined, assured, audited or provided by a third party such as an accountant, require an accountant to provide a letter of comfort or similar on the financial information. So despite that aspect of the guidelines being released under the Small Business Commission in Victoria, we're still getting a lot of landlords asking for some kind of information to come from the tenant's accountant, which I don't think is unreasonable because it should be coming from the accountant in my view. And my clients personally haven't been that reluctant to pass on that information. They have gone to their accountant and discussed in conjunction with their accountant what they think is reasonable to give to a landlord. A landlord will obviously be asking for more, so it's about trying to find that balance. And we're having a discussion before we start this session. It's been 7 weeks since I have lived and breathed this particular type of work and negotiations, and I'm yet to have one landlord and tenant agree on rent relief yet. So it just goes to show where things are at between landlords and tenants. And obviously the process for not agreeing is that it goes to mediation in every state and territory. So I'll just quickly brush on what the states and territories positions are because I know we've got people from quite a few different jurisdictions listening in. So New South Wales have implemented their, it's called the Retail and Other Commercial Leases Regulations. So they have been implemented in New South Wales. They are actually the closest to the code that you'll get across Australia. They basically mirror the code and the 14 leasing principles set out in the code in New South Wales. So it's a very different process and they're not as prescriptive as here in Victoria. So it's quite a different landscape of how this all looks in New South Wales. Western Australia has issued the Commercial Tenancies Response Act, but they yet to issue the regulations specifically for commercial tenancies. Tasmania has also released their equivalent regulations. It's a bit weird the way Tasmania's done things. It's a very short piece of legislation, not like New South Wales, Victoria or WA. It just basically talks about a declaration being made on the 9th of April 2020 prohibiting the termination of a lease for unpaid rent for commercial tenancies where the tenant's turnover is more than 50,000. It's currently got their National Code of Conduct for Commercial Tenancies passed in both houses, but it's waiting for its royal assent. In Queensland, we are still waiting to see the regulations in Queensland. They haven't progressed still. They've got the COVID-19 Emergency Act, which is the first layer, but not the next layer down, which enacts the actual law. In South Australia, we still haven't seen, again, regulations to come out of South Australia. In the ACT, we have seen the Leases, Commercial and Retail COVID-19 Emergency Response Declaration Act come out. Again, not that prescriptive, just talks loosely in terms of the breaches and the principles coming out from the mandatory code. And in the Northern Territory, we've also got some legislation that's come out. So that's the state of play currently in the country. And what I want to make a point to all of you is if you've got a lease and you have, I'm assuming that you are all in a situation where you've suffered some kind of downturn in turnover. It's really important that you understand what the law requires you to do as a bare minimum to get the protection of the regulations and write to your landlord and make sure you comply to get that protection. What people don't understand is they think that they've automatically got the protection of the regulations and the code. The code is just a set of guidelines. The code is not the law. The code will not help you. It will not protect you. It's just guidelines. First thing to note. Second thing to note is you do want to make sure you initiate the process with your landlord properly by providing your landlord with what you need to provide them to get the protection of the regulations in your particular state or territory. So the example I used before from the first slide, I think in Victoria you have to write, giving them a statement saying you are an SME entity. That's what I mean by following the process to get the protection of the actual regulations in your state or territory. Another really important thing for you to understand is once you have agreed to a suitable rent relief for between yourself and the landlord, you've got to make sure you document it properly. And by documenting, I don't mean a set of emails passing between parties. In Victoria, for example, our regulations specifically provide it must be documented by a deed of variation or by a memorandum of agreement. In any event, I can guarantee you your lease, every single one of your leases will provide that any variations must be agreed in writing and be effected by a deed. The other point to make is people come and go, landlords change, they sell the freehold, people die unfortunately, new landlords come along, they inherit it. So if you haven't got this documented properly, because it does survive a certain period of time after the pandemic, it could cause you problems down the track. The other thing that's interesting to make a note of, and I'm speaking generally now because again, every state and jurisdiction, state and territory differs, the regulations provide that your lease can be extended. So the landlord in Victoria, for example, has to offer a 6-month extension on your term of lease to help you see out the other side of the pandemic period, to trade out of this. You don't have to accept that extension of lease, obviously, but it does actually say that when they're making the offer to a tenant for rent relief, they have to offer an extension of the lease term. What is interesting is that if you have a lease, say, that's ending in a year, and you've got the right to repay the deferred rent for 24 months commencing after the end of the pandemic period, so in Victoria, 29 September, you're going to find yourself in a situation whereby the lease has actually come to an end, but you've got continuing obligations that survive after the lease has ended. So we're probably going to see a host of all sorts of other issues coming out of this, because what the government hasn't turned their mind to is what happens in that situation. Does the landlord still have to give back the tenant their bank guarantee, for example, given that they've got ongoing obligations that survive the end of the lease? So I don't blame the government. They've obviously acted on their feet in trying to get this legislation out there to try and help tenants and landlords. But there have been some issues and there are loopholes, and we'll probably see more and more problems as this all plays out in practice. I guess the most important thing to take from today's presentation is if you haven't reached an agreement or if you're having trouble, consult a lawyer, make sure you know what you're doing, make sure you're getting the best outcome you possibly can, make sure you get the protection under the regulations by doing the right thing, following the process. Remember, the code is just the code. You've got to look to your actual regulations in each state and territory. And understand too about the turnover side of things. Be reasonable in your negotiation. Everyone's supposed to be acting in good faith. You're trying to reach a suitable resolution with your landlord that suits you. some people have been talking about doing things like, you'll probably know this from paying outgoings, but some agreements that people are talking about that might be fairest between landlords and tenants is whereby you agree to say a 50% rent deferral or waiver. So half of that, 25% would be deferred, the 25% would be waived. And then at the end of the pandemic period, you actually do a reconciliation. So if business is booming, you'll have to pay back some of the rent to the landlord. If things get worse, then it can go the other way as well. So people have been talking about doing an agreement subject to a reconciliation at the end of the pandemic period. This is only attractive for landlords who know that the tenants can't fudge their figures, for want of a better phrase, because obviously things like little takeaway shops where they can do a bit of, cash sales, you wouldn't want to be entering an agreement with those sorts of tenants if you were a landlord, because they can clearly fudge their figures and that would work against the landlord. So it will depend on your type of business and whether the landlord would agree to that. And the other thing to take note in Victoria especially, not sure about the other jurisdictions, haven't looked at that yet for the other jurisdictions because it hasn't come up as yet. You actually have a right to go back again if your situation materially changes, even though you've made an agreement. So if in Victoria, for example, you've made an agreement, but in 3 months' time something happens, your business gets worse because there's further closures, further restrictions, you do have the opportunity to go back to your landlord and ask for further rent relief. So that's what the situation in Victoria is. So you can keep that in the back of your mind as well. And I do know that in New South Wales, for example, because they haven't spoken about in their regulations that the offer from the tenant, from the landlord to the tenant has to be for the full 6 months. I'm seeing a lot of landlord and tenants coming to an agreement for 3 months, which is not a bad thing because after that 3 months, you can always go back and renegotiate again based on what's happening. At the moment, cafes are opening, for example, so things are changing and the government's constantly changing the lifting of restrictions. So that what type of impact that has on your business, I'm not sure, but that's something to consider as well. I think that was all. We've spoken about the Victorian Small Business Commission guidelines, so I think we'll see if we've got any questions, if that's okay, James.
Oh, they're there.
Hello.
He's coming back.
Oh, he's coming back, yep.
Hello. Yeah, thank you very much, Evelyn, for that informative presentation with real examples across the country. You mentioned the majority of your clients haven't still reached an agreement when it comes to rent waivers and deferred rents. A question we received is, what happens if a landlord and a tenant are unable to reach an agreement?
Oh, yes, sorry, I've got to touch on that, of course. So mediation, good old mediation. So in Victoria, the Small Business Commissioner is taking on all mediations for all types of disputes if they can't reach an agreement. So if you've gone through the whole process in the regulations, you've tried to negotiate in good faith, you just can't reach an agreement, you need to lodge an application with the Small Business Commissioner in Victoria, the same in the other jurisdictions, and apply for mediation. That all sounds great and wonderful. At the moment, there's a huge backlog in Victoria. The turnaround time from the sort of start to finish used to be about 14 days. It's currently between 8 and 12 weeks. Although I have been told that a lot of these applications for mediation in Victoria have been thrown out because they haven't actually followed the process and the regulations. So they sort of got in a bit too early. I've actually been advising clients, there's certain clients that I have, I can just tell they're never going to reach an agreement. And we've been going for weeks. So I've already told those clients to lodge to make sure they're in the queue. So I had quite, because it's free. In Victoria at the moment, it's free to lodge. It doesn't cost a cent. There used to be a filing fee. At the moment, it's free to lodge. So the process is a mediation. So the way mediation works, as you may or may not be aware, is the parties get together at the Small Business Commission. There's a mediator. Everyone tries to reach an acceptable resolution. And once that, assuming there is a resolution to the rent relief between the landlord and tenant, that then becomes a binding mediation, a binding result that can be documented by way of deed of variation. If the parties can't agree at mediation, the next step would be going to court, which you would want to avoid for obvious reasons. So we're hoping that everything will be resolved at mediation stage. No one's got a lot of money to throw at a court application at the moment, so I can't see many going off to court. But yeah, mediation is the answer to that.
Thank you, Evelyn. Before I ask the next question, if anyone that's watching has a question they'd like to raise, please feel free just to tap on the Q&A button and type in a question. I'll go ahead. Something you touched on earlier in the presentation was that landlords are asking for excessive information and tenants are reluctant to give too much financial information away. This might be used against them for future rent levels, but it's probably worth reminding the members once more, what is the appropriate level of information for a landlord to request in terms of turnover and rent relief?
Okay, so as I mentioned in Victoria and in New South Wales, the Small Business Commission has issued a set of guidelines. Again, they're just guidelines, they're not the law. So what I've been telling clients is you should stick to the guidelines, because obviously when you go to mediation, what the mediators will be using as a benchmark is their own guidelines, even though it's not the law. So in terms of what to give and what clients and accounting consultation with their accountants have been agreeing to give is extract of their back statements for the last one financial year prior. Some people have been happy to give 2 prior financial years, because obviously a landlord needs to say, okay, in the equivalent quarter from last year you made X dollars, the equivalent quarter this year you've made X dollars. All we can do is project for the quarter after that. So they do have a right to ask for some information, but unfortunately there's no law prescribing what that information is, James, and that's why we've got this problem with trying to satisfy everyone's requirements. I've been recommending to my clients to speak to their accountants as to what they think would be reasonable to give without giving too much information. But I think that the back statements would be a starting point. So if you're making an application to your landlord for rent relief, I would give them your BAS extracts from the last financial year and this financial year to show the downturn turnover and to substantiate your good faith request for rent relief. At least you've got something showing we've got a 50% downturn, here's the evidence, therefore we would like a 50% rent reduction. And half of that's a waiver, half of that's deferral.
Thanks, Evelyn. I think that answers that question. I've got a question from Victoria, and it's come in 2 parts. So we'll deal with the first part to start with. And it goes like this. If a formal request for relief has been made and no offer of relief has been received from the landlord within 14 days, is the only option to lodge for mediation?
Well, at first instance, I would go back and say, you haven't complied. We're trying to negotiate in good faith. Can you please let me have your offer for rent relief? But if they don't respond yes, the next step would be you'd have to go off to mediation. And clearly you would be alleging to the landlord that they're not complying with their obligations under the regulations, and they're not acting in good faith in accordance with the code. So I've sent quite a few of these emails and letters myself to landlords. You would hope that the landlord realises, I'm pretty sure in Victoria, I'll just check, it's actually a breach. So if a landlord doesn't respond, just let me check. Yeah, it is a breach. There's no penalty, unfortunately, but there is an actual breach to do that. So if you engaged a lawyer, if you didn't engage a lawyer, the lawyer would be saying, if you engaged a lawyer, you've breached your obligations pursuant to Regulation 10.4. Provide us with a response. Otherwise, we'll lodge with the Small Business Commissioner. We'll lodge our dispute notice with the Small Business Commissioner.
Okay, thanks, Evelyn. And the second part to that question is, once an offer has been received and negotiations begin, how long does each party have to respond to each other during these negotiations?
There's no prescribed time. You're just supposed to be acting in good faith. So again, they don't prescribe a time for those negotiations to take, to be finalised, but you should both be engaging with each other, landlords and tenants, within reasonable timeframes. I would say any longer than a week would probably be unreasonable. As I mentioned before, the reason for the stalemate hasn't been that they're not getting back to each other, it's just that everyone keeps asking for information, then the tenant disputes that information, then we have an argument about what information to provide. That's been the biggest cause of the delays from my experience. And people just not understanding the process and not making sure, the tenant's not making sure they've given the landlord everything. The landlord quite cheaply delays it by saying, well, you haven't given us what you're required to give us, so we're not required to respond.
All right, thanks, Evelyn. Well, we haven't got any more questions in the Q&A part of our Zoom meeting. So if anyone does have any questions after this, please feel free to email them through and contact Mason Sear Turnbull through our HRNet contact details on the website. Evelyn, is there anything you'd like to add to wrap up before we finish off today, and then I'll close out?
Look, not really. Just probably the last thing I will say is just remember that we don't have any precedent. We don't have any examples as to what all this means in practice, because it is new law. So if your lawyer or if your consultant is telling you we don't really know what this means or how this is going to work out, it's because we genuinely don't have any precedent yet. So there are problems with the way the laws have been drafted, but if everyone tries to act in good faith, hopefully everyone can get a resolution. And one thing I will say is I have had landlords who have offered straight out rent relief, complete rent waiver. So there are some people doing the right things. It's just there's also the other side as well. I wish everyone good luck, and I hope you all get through this period as easily as possible. It's hard times for everybody.
All right, well, thank you very much, Evelyn, and that concludes our webinar for today. And thank you all for attending. As always, your feedback is appreciated, so please take a couple of moments to complete the survey that you'll receive at the end of this webinar. The HRA's goal through these challenging times has been to focus on activities that will ensure our members come out on the other side of this in as strong a position as possible. And we'll continue to provide assistance via updates to our members over the coming weeks and months on the dedicated coronavirus webpage, as well as through emails and social media. Don't forget, members have access to HRNet through MST Lawyers, as well as accounting and business advisory service through our HLB Man Judd partnership. These contact details, as well as other online resources, can be found in the member section of the HRA website. As always, the National Office is here to assist, so please feel free to reach out. Thank you all for dialing in, and stay safe.